week on the policing of youth in conflict with the law. I'm going to give a relatively short lecture that's going to just cover some broad-based topics regarding the policing of youth. And then as part of today's lecture, you'll be required to watch a video on Mr. Big sting operations. I want you to think about, especially for the final exam, what the pros and cons of using Mr. Big stings are, with specific reference or specific thought towards youth. So how might youth be especially vulnerable to Mr. Big stings, and how might they be more likely to sort of give a false confession as part of a Mr. Big sting? And I know that we do have some individuals in this class who are interested in policing, so I want to talk a little bit about opportunities with the police in Vancouver as it relates to the policing of youth. So we actually have specific designated cars or units in the Vancouver Police Department dedicated to the policing of youth. And it's not just for individuals that are police officers, it's for probation officers, social workers, mental health experts, and so on. So one of these cars or one of these units is called the Yankee 10 car, which consists of a youth probation officer and a police officer. And their role is to monitor youth in conflict with the law. So checking in on them to make sure that they're abiding by their probation conditions, that they're not with anyone that they're not supposed to be, that they're not using drugs or alcohol, and that they aren't committing any new crime. Another more proactive part of the Yankee 10 car is to basically locate and identify high-risk youth and liaise with other community agencies to try and get these individuals help. So it's not so much about arresting the youth, detaining them, placing them in sheriff's cells, or charging them so they'll end up in court. It's more like working with other communities. One of them is the Covenant House, to try and keep these young persons safe and potentially off the street. So there are other organizations like the Downtown Eastside Youth Activity Society that are basically designed to work with health units, for example, a psychiatric nurse, to try and make sure that these individuals are not at risk of victimization or at risk of harm. So it's not just about monitoring problem behavior, it's about monitoring health. And so this can actually cause some controversy. So it might on the surface sound like a good thing, but then it can also, some would argue, is over-policing these young persons, where these young persons are constantly being monitored by police, increases the likelihood that they'll be detected for a crime, and maybe increases their likelihood of ending up in jail or in custody. So there are pros and cons to this. There can be, on the one hand, it's good to be proactive and to help sort of coordinate with other agencies their response to the young persons that might be in need. But on the other hand, it might be further targeting a population that's already vulnerable. On the note of persons that are vulnerable, there's also another car called the Yankee 20 car that's meant specifically for street entrenched youth, and it's for high-risk youth that might not just be at risk of crime, but things like early mortality because of the use of drugs, and especially recently due to the overdose crisis in BC, this has become especially important. If you follow persons like Kim Boland, they'll be very useful on Twitter in updating you about the overdose crisis, but also other crime-related topics, especially gang involvement. And I'll talk about gang involvement in the upcoming sort of special topic. I think it's 2 weeks from now or a week from now. For the Yankee 20 car, it consists of a BC Ministry of Children and Family Development representative, usually a social worker, and a VPD officer, and they're especially looking to respond to youth that are being sexually exploited in the downtown east side or elsewhere, and youth that are at risk of victimization who are between the ages of 12 and 18. What's very important to know is that the majority of crime perpetrated by youth goes undetected. So most youth that engage in crime don't actually have any contact with police because that crime is undetected. But when we do have police officers in contact with youth for an initial offense, basically crime is more likely to be detected in areas where there's a greater police presence. And I talked about this a couple of weeks ago, where maybe we're in a situation where the overrepresentation of certain marginalized groups is perpetuated because of over-policing. There are specific neighborhoods that are higher in crime, and so communities activate to place more police officers in these neighborhoods, and the result is an increase in the detection of crime, so a further increase in the crime rates in those neighborhoods. So we have to think about how we're allocating police resources and how that can influence an increase in the crime rate. Some people might think, oh, if we put more police officers in these neighborhoods, then the crime rate will go down. But that's not necessarily the case, especially if individuals aren't being deterred by this increased police presence or don't even know that there's an increased police presence. So in some cases, the crime rate could actually increase. Also very important to understand that police have a lot of discretion, especially when it comes to minor offenses. We talked about the Youth Criminal Justice Act last week, and in that case, police are expected to basically, for first-time youth offenders involved in minor offenses, not to actually arrest, or in BC it'll be, instead of charging youth, recommending charges to Crown. So in BC, police officers never actually charge anyone. There's a specialized Crown Counsel that is responsible for looking at whether or not the evidence for a particular case is strong enough to pursue charges, or even if the evidence is strong enough, they have to ask whether the prosecution of this person is in the public's best interest. So if it's a person who's involved in a particularly non-serious offense, Crown Counsel might decide that this isn't in the interest of public. It's going to cost too much to prosecute this offense. This offense isn't particularly serious, so it's not worth moving forward in court. When police officers are using their discretion, they can issue warnings and simply release the young person, or they can take the young person home and talk to their parents and leave it up to the parent to administer some form of punishment. Can also take the young person to the station, maybe write them up, and their information will be entered into what's called PIRS, the Police Information Reporting System. So this isn't a system that records like official criminal records or even official arrests. It's more like incidents or reasons for a person to have contact with police. And so they could be taken to the station, entered in PIRS, and then just released again. And the officer might simply write the youth up and just say, okay, go, like you're in our system, we'll know for next time that you have been given a warning, and if you continue this behavior, maybe more formal steps will be taken. When it comes to more serious offenses, police do still have some discretion, so they can still refer a young person to a specific community-based program. For example, the ones that I talked about that are operating in the downtown east side. In the city of Surrey, they have the Yo Bro, Yo Girl programs, rap programs, all designed to try and help keep young persons out of gangs or help facilitate those young persons from leaving gangs. So the police officer might feel that maybe referring this young person to this particular program would be more useful in helping to prevent them from committing crime in the future. In other cases, maybe because of the severity of the offense, it's deemed necessary to arrest the young person and hold them. As I mentioned, they can be charged with an offense in certain provinces, but in BC, the police officer isn't the one actually administering the formal charge. And in especially severe circumstances, the young person can be held in custody. And they can be held in custody for a variety of reasons. They could be held in custody simply because the police officer needs to establish the young person's identity, or prevent a future offense, or to secure evidence. Or if the offense is deemed especially serious, they might be held in custody where they'll await their bail hearing. And I'll talk a little bit in a few weeks about what the bail hearing is and what the circumstances are in which someone might be denied bail. But for now, I just want to focus on the policing aspect of youth crime. Extra legal factors refer to things that are not prescribed by law that nevertheless impact a police officer's decision about whether they're going to proceed through formal or informal sanctions. So extrajudicial measures, for example, versus arrest and recommending charges to Crown Counsel. Since the YCJ, we've seen an increase in the use of informal measures, and at times this can be concerning because of the potential for systemic racism to exist within policing. And I would argue that it does. And that's not necessarily to say that it's something that's unique about policing. We can find examples of systemic racism in a lot of different institutions, not just police. But as some evidence that there is systemic racism within policing is the fact that minority youth are more likely to be arrested and have a record. And I'm not just talking about how minority youth are more likely to be arrested compared to non-minority youth. What I'm talking about is minority youth are more likely to be dealt with by formal measures compared to other youth who maybe are also involved in crime, but they're more likely to be given informal measures. So we might see that for a Indigenous youth or a Black youth in Canada, they'll be more likely to be arrested or proceeded with more formal sanctions by police officers compared to white youth involved in the same offense and the same circumstances surrounding the offense. So how does the systemic racism issue get perpetuated within police forces? Some of it can come from police officers' beliefs that Black and Indigenous youth are more difficult to deal with. And this can in turn impact how the youth is going to respond, what their demeanor might be towards police officers. So I'm not saying that youth are never initiating negative contacts with police or are never on their own having this negative demeanor or negative anti-police attitude, but we can also get this self-fulfilling prophecy where police officers expect certain youth to have a particular negative attitude towards police, so they might be more punitive in response to the youth, and the youth recognizes this and in turn is more hostile towards police. So we can see this sort of vicious cycle, and that's why certain communities have tried to emphasize more community-based solutions. And again, some would argue that this isn't necessarily a good thing because it simply results in the over-policing of specific groups. So if police are not worried about the relations that they might have with rich, white, or upper class communities regardless of race, maybe they're just going to focus instead on those communities that traditionally have had conflict with police. But now police are there's more of a presence in those communities, and maybe that makes certain people feel less comfortable or increases the likelihood that crimes are being detected and further punished by police officers, so we can get that net widening effect that I've talked about in past weeks. It's not just about race, it's also about class, and we can see differences in how police respond to youth crime depending on the types of neighborhoods that individuals live in or the socioeconomic status associated with that particular individual. For example, police officers may be, and in fact are more likely to arrest youth or detain youth who are coming from lower socioeconomic backgrounds. And this can be in part because they feel that maybe the parents aren't going to be home or are less often around, and that's not necessarily an accurate perception, but it's what their perception is. And because of this belief, they feel that if we bring the youth home, they're not going to get punished by the parents, so we need to do the punishment ourselves. Whereas if it's a kid coming from a more affluent community, maybe they feel that, okay, this is something that can be dealt with by the parents or dealt with by the school and doesn't require formal police involvement. If the young person is not acting in a way that maybe police officers are used to or expect, and this can be influenced by the young person's mental health symptoms, then the police might be more likely to respond more punitively to this young person because they believe that these mental health symptoms are in fact instead a sign of sort of agitation towards police or more worthy that young person is of being arrested. We can also see, in terms of additional extralegal factors, how girls are treated differently than boys by police. And it's kind of something that I think I've talked about in the past when talking about crime rates in Canada. When it comes to the policing of girls, police officers are more likely to, let's say if we have a girl that's 13 years old and a boy that's 13 years old, and they've both been involved in the same offense in the same circumstances, police are more likely to respond more punitively to the girl compared to the boy. Part of this can come from protectionist concerns, which again are not legitimate concerns. It's where the police officer thinks that the social issues facing the young person need to be dealt with through the justice system. And again, the justice system isn't designed to deal with these social, mental health, substance use, poverty issues. And so the police officer is responding more punitively to the young person's social circumstances as opposed to the criminal behavior that they have been involved in. So, girls who are younger are kind of seen as this is something that is violating gender norms, and the police officer believes a more punitive response is necessary. On the other hand, when it comes to older boys and older girls, older boys are more likely to be arrested and charged compared to girls of the same age. And this can be based on the belief that these boys have had their chance in the past and it's time for them to grow up. And by being more punitive, that will help facilitate them sort of learning a lesson. Something that I forgot to mention, but it's also important in terms of differences in the socioeconomic status of different communities, is that more affluent communities might have greater resources available to young persons in conflict with the law. And so that increases the likelihood that the police will rely on these alternative measures in the community as opposed to an arrest and charge. So if particular governments don't invest the money in these community-based agencies, then police officers won't necessarily have the resources available to them to refer that young person to one of those agencies, so instead they might be more likely to arrest that young person. We've seen protests in Vancouver and across the world about the mistreatment of Black, Indigenous, and other persons of color by police. We still see, for example, increases in the likelihood of arrest based on the racial status of the young person, and this is true across Canada and across the United States. One of the reasons for this, according to past research, is also not just the police, but the complainants, especially in the United States, but it can be true in Canada as well. If it is a white complainant and the complaint is against a person of color, then there's more of a likelihood that the complainant is going to request that police arrest or charge that person, compared to if it was a white complainant and the complaint was against a white perpetrator. I've talked about overrepresentation in the past, but just to put some numbers to it, Indigenous persons are about 8 times more likely to be incarcerated, and obviously that can't happen without overrepresentations in arrests as well. And this can be in part because of, as we've talked about, the over-policing of areas that are overrepresented by Indigenous persons to begin with. And many of these extra legal decisions being made by police are what have contributed to the call for defunding police movements. And I think part of the reason why there can be such a wide disagreement about whether we should or should not defund the police relates to a lack of clarity about what defunding the police actually means.
If you've been to a protest or have been paying attention to the news lately, there's a good chance you've heard this.
Defund the police.
Defund police departments.
Defund the police.
It's a rallying cry that has gained traction following the killing of George Floyd by police and the outbreak of global protests against anti-Black racism and police brutality. In past high-profile cases of Black Americans being killed by police, activists have called for police reform. But now they're pushing for a more radical change, defunding police departments and reimagining what public safety looks like.
No justice! No peace! No justice! No peace!
Before talking about the idea of a world without the police, we have to understand how they came to be in the first place. Police forces in northern colonial America were initially developed in response to an increase in immigration, which caused a population boom and racial and ethnic conflict. In the South, the first police departments were known as slave patrols, whose sole purpose was maintaining control of enslaved African Americans. And in Canada, early police forces were developed to forcibly remove Indigenous people from their lands.
And you can see how the police engage with Indigenous and Black communities to this day remains connected to that history of our humanity not being respected from that institution at its very inception.
Although defunding the police seems like a pretty straightforward concept, there's still a spectrum of thought around it. On one end, you have groups that want to defund the police and eventually abolish police departments entirely. And then on the other end, there's people that want to simply cut some money from police budgets and scale back their activities. Regardless, the basic concept is this: money should be taken away from police departments and reinvested in social services like education, housing, mental health, and alternatives to policing. And that idea has already started to become a reality in Minneapolis, Minnesota, where George Floyd was killed. The majority of members of the city council there recently announced that they intend to defund and dismantle the city's police department.
5 years ago, when people went out on the streets after the police murder of Tamir Rice and Eric Garner and Mike Brown and so many others, people were told, don't worry, we're going to fix it. We're going to give the police implicit bias training. We're going to have police community encounter sessions. We're going to give them body cameras and everything will be fine. But now it is clear to everyone that the police are not going to reform themselves, and that the only option is to take their toys away and diminish the scope of their power.
And while defund the police is now a part of the mainstream lexicon, it is not a new idea. Its roots can be traced back to the late 60s and early 70s, when the concept of community control of the police began to take form in academic circles and within groups like the Black Panthers. But the idea of defunding the police, as we now understand it today, emerged from the period of mass incarceration in the 80s and 90s, and the development of the prison abolition movement.
There were dozens of campaigns underway across the country before these recent events calling for dialing back police budgets and shifting those resources.
The idea is based on a recognition that policing itself is a form of harm, especially for Black communities, and that no amount of reform or training will be effective at preventing future police violence because it's an institution designed by the state to use violence to fix problems. And over the last few decades, across North America, the police have increasingly become the go-to solution to more and more of society's problems.
We're asking cops to do too much in this country. We are. We're just asking us to do too much. Every societal failure, we put it off on the cops to solve. Not enough mental health funding. Let the cop handle it. Not enough drug addiction funding. Let's give it to the cops.
And then we tell the police they're waging a war on crime and a war on drugs and a war on gangs and a war on immigrants, and we've infused them with not just military equipment, but a military ethos that gets them to view the public as this force to be neutralized.
In both Canada and the United States, Black people are more likely to be killed by police officers than white people are.
But beyond killing us, we know that we're disproportionately arrested, disproportionately surveilled, disproportionately jailed. So we're talking about systemic racism. We're not just picking police and a couple of incidents of death. We're talking about the conditions of our lives every day.
Opponents of defunding the police often favor police reform instead, and say, if we abolish the police, what are we going to do when violent crimes occur, like murder and rape?
Murders and rapes happen even with these massive police forces. And mostly they come and just take a report afterwards. They're not preventing that stuff from happening sufficiently. Where are the prevention interventions?
People like Vitali and others argue that getting rid of the police also requires coming up with alternatives to policing that better serve community needs, and that address the social factors that lead people to commit crimes in the first place, such as addiction or poverty. For example, taking millions of dollars from the police budget and allocating those funds to build public housing, or developing a mental health response program to assist people in crisis. There are many obstacles that lie ahead, though. While Black Lives Matter has gained significant public support in the last few months, the police are historically popular, especially among white Americans. But in a time when local budgets are strained due to the recession caused by the coronavirus pandemic, and as lawmakers across the US and Canada re-examine public safety amid weeks of protests against anti-Black racism, activists are arguing there's no better time to divert funds from police departments to communities in need.
People have lost the thread And they've forgotten that the purpose of our interventions is not to decide whether the police are responsible or not, but it's to stop violence and death from happening in the first place and provide appropriate and caring responses. And that's what abolition means. It means providing a caring, non-lethal response instead of pretending police can solve every problem. We have to decide what our priorities are and why the violence has been the priority for so long. It has to change.
I think as a starting point to kind of bring groups that are divided together is to begin to think about what are police doing that shouldn't be their job to begin with, and jobs that the police officers don't want. And you'll often see police officers and police chiefs talk about how the majority of their calls to service, especially in Vancouver and the downtown east side, are related to calls for help relating to mental health, not related to criminal behavior. And if this is the case, and if police officers are openly acknowledging that they are not equipped or trained to respond to persons who are having mental health crises, then maybe this is a good reason to defund police to a certain extent, so that resources can be diverted instead to having, maybe in addition to a police officer, a mental health expert, a clinician, a social worker, an advocate in that community, and can go and attend to the individual in this mental health crisis to try and help deal with this social community problem, as opposed to making it a justice system response. Legal factors affecting police discretion are basically factors stipulated in the criminal code dictating the police officer's almost obligation in terms of how to respond to a young person. So it sort of sets out rules for how police should be using the discretion that they have. And these rules are based on things like the severity of the offense. So if it's a particularly serious offense like homicide, they're obviously not going to be just referring this young person to a community program. They're probably going to be arrested, held, and basically detained in sheriff's cells or pretrial detention, awaiting their bail hearing to see whether they'll be released or held on remand. Prior police contact can also influence the decision to arrest or release, so detain or release. If the young person has had a lot of prior negative contact with police, maybe they're going to say, okay, you've been referred in the past, you haven't responded to this, and it's in the best interest of the protection of the public, which, remember, is one of the ultimate goals of the YCJA. So to protect the public, it is now necessary to use something like incarceration, and again, not necessarily for deterrent purposes, but for, we need to put this person in custody simply because they are a risk to harming the general public. If a young person has been convicted in the past of an offense, it can increase the punitiveness with which police officers will respond. So remember, under the YCJA, there are those 4 gateways that are considered when a judge decides whether a young person should be sentenced to custody or not. In this case, one of those considerations is past criminal record, and that can influence police officers' decision making. Similarly, if they have failed to abide by court orders in the past, so they've breached a probation order, for example, then the police officer is more likely to respond punitively. And finally, there are specific rules in the criminal code that say that a person should be detained, for example, if it's necessary to determine that person's identity, if it's necessary to detain them in order to collect evidence, or if it's necessary to detain them because it's believed that there will be a threat to the victim in the future by that particular person as well. What can police officers actually do? So this is all about police dispositions. One of the things that they're supposed to do right away is consider the appropriateness of an extrajudicial measure, as we talked about last week under the YCJ. These are things that must be considered and are presumed to be an adequate response to the young person if they have not committed a violent offense and if they have no history of prior offending. And just because it's a violent offense, or just because they do have a history, doesn't mean that an extrajudicial measure cannot be used. It's just that it's automatically presumed to be adequate if the young person doesn't have any of those prior criminal record examples. The whole purpose of extrajudicial measures is to divert the young person from the formal court system. And by doing so, the police officer can warn the youth, issue a caution, or refer them to a community agency. And this might sound like a really minimal response to the young person, but that's the point. The point is that if you respond especially punitively to a person that's not involved in an especially serious offense, you can actually increase the likelihood that they're going to offend in the future. In Canada, especially through correctional and forensic psychology, Andrews and Bonta developed what's known as the risk needs responsivity model. And part of what this model dictates is that if you have a person that's a low risk to reoffend, but you respond especially punitively to that young person, it can actually increase the likelihood that that young person will continue to offend. If it's a situation where an extrajudicial measure is not appropriate, the police officer can then either lay a charge themselves, or in the case of BC and Ontario, they can refer the case to Crown Counsel. And when Crown Counsel gets the case, they can do three things. They can either approve the charge and have the young person dealt with through the formal justice system, or they can say maybe an extrajudicial measure would have been appropriate and basically refer the young person back to the community, or issue what's called an extrajudicial sanction, which is basically just a more intense version of an extrajudicial measure. The way an extrajudicial sanction works is usually there will be some form of restorative justice conference or mediation or reconciliation, and then the young person will be required to abide by the agreement that emerges from that restorative justice conference, as an example. And if they do not meet the stipulations in that agreement, then they can receive formal charges for failing to comply with the extrajudicial sanction order. Usually Crown Counsel are unlikely to be using extrajudicial measures. They're more likely to issue extrajudicial sanctions, because it's kind of like, if the case has got to Crown Counsel already, it's because an extrajudicial measure was deemed to be inappropriate. The reason why extrajudicial measures would be used in the first place is related to that idea of stigma, the negative consequences that can come from labeling a young person as an offender, and we want to use least possible interference. The idea that this will decrease the likelihood that the young person will experience stigma, but that will still allow the young person to be held responsible for their actions. So again, remember the YCJ says that the public will be protected by making sure that the young person is held responsible for their actions. And responsibility doesn't mean being punitive. It means making sure that the justice system response is proportionate to the behavior engaged in. The likelihood that extrajudicial measures are actually used can be dependent on the community that's being policed. If certain communities don't have these referral programs, they don't have the resources to respond to young persons in that way, then police might be more likely to consider that an extrajudicial measure is not appropriate because it simply isn't available. And so we can see almost, a two-tiered justice system where individuals from more affluent communities are more likely to experience diversion, whereas individuals from less affluent communities are less likely to be diverted. What this ultimately comes down to is more of a structural issue in terms of inequalities, but especially inequity, where certain individuals just don't have the access to these programs, or maybe certain programs are underfunded, or maybe in the communities that are most in need, we should have even disproportionate funding, specifically more funding for those communities in need. That is what would create equity, where these young persons are coming from extreme disadvantage. So the types of programs that are required to help address this disadvantage need to have even greater levels of funding to get that young person sort of on an equal footing with others who are coming from more affluent communities. The argument that I think some would make would be, well, why is it fair for those individuals who are earning more of an income to have their tax dollars go towards building up people in different communities who aren't paying the same amount of taxes? And what I would argue is that this is not a paying of taxes. Instead, when we have evidence-based programs, it's instead an investment. It's an investment in the community that is going to help those young persons stay in school, be able to attend university, get jobs, and in turn begin to pay taxes and contribute to the economy on their own. So it's not as if it's just a handout, it's more an investment to help address this inequity that can then lead to these individuals being able to help contribute further to the different community programs, social services that are needed in Canada. Mediation, reconciliation, and restorative justice conferencing don't always play out in the way that is intended. Sometimes it's just not effective because, say, if it's a business that's been victimized, a young person shoplifted, they don't want to participate or pay for the employee to go and attend this conference because it's just more money out of their pockets. They might have experienced a robbery or a burglary, and now they have to pay more money to take time off work to go to this conference. So sometimes these conferences aren't effective that way if they're costing businesses additional money. Sometimes it can actually lead to the individual involved in the crime being prosecuted in kind of two ways, one through the formal justice system and one through the civil system. So it's not necessarily actually helping the young person be diverted, it's actually leading to even more negative ramifications. And again, it's not to say that persons that have committed crimes should not experience negative consequences, but they shouldn't experience negative consequences that are disproportionate to the behavior that they've engaged in. They should not experience consequences that are only going to exacerbate the likelihood that they continue to engage in crime. If we punish somebody by suing them in civil court and then they now owe $5,000, but the reason why they were offending to begin with was poverty, maybe you think that you're getting justice because now this person is repaying their debt. What happens if this justice is actually going to increase the likelihood that somebody else is going to be victimized because now this person has to commit further crimes to be able to repay that debt? Sometimes the decisions that are made at these hearings or these conferences can be more punitive than what the consequences would have been if the young person just went to court. Because at court, at least there's a judge that's aware of case law or precedent, aware of criminal code stipulations, and say, no, we can't have this disproportionately punitive response. But at these conferences, especially if it's somebody who's poorly trained and who's being the mediator, or if the young person doesn't have a lawyer to help represent them, then the outcome might be especially more punitive. And again, the goal of this conference is for it to be less punitive than what would happen in court. Reintegrative shaming is useful. This is where the young person's behavior is brought into question, but it's not as if the young person is then being ostracized from their community. The behavior is specified as the problem, but the young person is brought back into the community. But there can also be negative elements to shaming where the process is so adversarial and so punitive that the young person feels further disconnected from their community, which might further increase their likelihood of continuing to offend. So for the remainder of the class, I'm going to focus more so on the procedural aspects of policing and how police have to be attuned to not just the Charter, but also the YCGA. So when it comes to arresting young persons, and really all persons, the most relevant sections of the Charter are sections 7 through 10. Section 7 stipulates that everyone has the right to life, liberty, and security of the person, which has to do with the young person's sort of interactions with police to be free, to be safe. Section 8 deals with search and seizure and the right to be free from unreasonable searches and unreasonable seizures, especially when it comes to things like invading a young person's privacy in school or in their own bedrooms. When it comes to Section 9, this is about free from being arbitrarily detained and imprisoned. And we could see this especially being violated under the YOA, but particularly under the Juvenile Delinquents Act, where young persons under the JDA were being detained based on status offenses. So under the JDA, an adult wouldn't even be punished for this behavior, but for a youth, the young person would actually be detained in custody. Under the YOA, we still saw this issue under Section 9 because young persons were being placed in custody, especially young girls were being placed in custody for protectionist purposes, where an adult would be released or granted probation or some form of community-based sentence. The young person was being arbitrarily detained. They're not being detained because of the nature of the offense. They're being detained because of the nature of their social environment. Section 10 refers to the right to legal counsel, which was definitely an issue under the JDA, where youth weren't necessarily being granted lawyers. Under the YCJA, it has to be made clear to the young person that they're not responsible for paying for the lawyer. The overarching concern in administering all of these rights is that youth and adults tend to have fundamental differences in terms of how they interpret what a right is. So an adult will typically interpret a right as something that they are entitled to. You don't have to ask for a right, you're entitled to it. And this is the true or the accurate interpretation of what a right is. For young persons in conflict with the law, they tend to see a right as something that they have to request or something that they have to ask for, that it is a burden to others for them to ask for this right, so they might be less likely to ask for a lawyer, for an example. So what are the additional considerations that police officers need to have when arresting a young person? These are all dictated by Section 26 of the Youth Criminal Justice Act. It says you can't just arrest the young person, you have to notify their parent or primary guardian. So if they're in foster care, you'd have to notify the foster parent. Sometimes they're under the care of a social worker, so in that case, the social worker needs to be identified. And when notifying the parent and the youth, has to state the reason for the arrest. When police officers arrest the youth, they have to issue their warnings and cautions just like they would with an adult. But the warnings and cautions have to be explained to the young person in a language that they can understand. The parent or the primary guardian also has to be told where the young person is being detained. During the YCJA, not so much now, but in the past, policing groups were frustrated with the details or the additional requirements that they had to abide by when arresting young persons. I think now police officers have just gotten used to these additional requirements and we don't really hear much complaint anymore. Basically, to summarize, and this is what I want you to continue to think about when we watch the video on Mr. Big cases and on the interrogation of young persons, is how the reduced maturation, moral judgment, and understanding of the law can impact how a young person is going to behave or respond when they're in police custody and being questioned by police officers. One thing that happens for youth that doesn't really happen so much for adults is the searching of lockers. The YCJA had to figure out specific grounds for the search of school lockers. So I'll back up by first talking about Section 8 of the Charter of Rights and Freedoms says that everyone has the right to be secure against unreasonable search or seizure. And according to the Supreme Court of Canada, the purpose of Section 8 is to protect a person's reasonable expectation of privacy. So the question becomes, does a young person have a reasonable expectation of privacy when it comes to their personal locker at school? And the answer is kind of somewhere in between. Yes, the young person does have a reasonable expectation of privacy unless the school has a reason to believe that the young person has in some way violated the school's policy and that it's necessary to search that locker for the furtherance of school rules and school discipline. But if, for example, the police want to just search a young person's locker because of a belief that there might be a piece of evidence there, but it doesn't really have anything to do with the young person's behavior at school or what a school's policy is, then the police are not allowed to just go ahead and search that locker. To give an example, if a young person was believed to have a firearm in their locker and I imagine most schools have policies about how you are not allowed to bring weapons to school. Then the school could search that young person's locker through the aid of a police officer if and only if the police officer was acting on behalf of the school, not of their law enforcement group, to search that young person's locker for the purposes of administering the school's own policy. Another concern is reasonable privacy within a youth's own room. Now, if the parents say that the police officer can't search the room, then there's no question the police officer cannot search that room without a warrant. What if the parent says, yes, you can search the room, but the youth says, no, you cannot search my room? Who owns the room? Is it the young person who has been given that room by the parents and all of their belongings are in there? Or does the parent own that room because the parent is the one paying the mortgage on the house and technically owns that room? And case law is contradictory. We still don't really know how these decisions are going to play out in court, whether it's going to be deemed that the young person themselves must give permission to police for the police to search that room without a warrant, or if it's acceptable for the parents to simply grant police officers the permission to search the young person's room, even if the young person does not want the police to do so. What I really want students to get out of this class, especially because I think there will be persons in this class who maybe they're not going to be police officers, but you're going to deal with youth in conflict with the law in some way, whether it's policing, probation, corrections. If you're a clinician, if you're Crown Counsel, if you're defense counsel, you're going to, at some point in time, be asking the young person questions. So this isn't just a policing concern. It's a, how do we talk to youth in a way that is going to make sure that the statements they provide to us are voluntary and accurate. And this is an issue because young persons are more susceptible to certain things. For example, they're more susceptible to feel that they have to provide a response to questions when they come from a person in authority. So if a police officer asks a young person a question and the young person has a right to remain silent, the young person might feel, I am obligated to respond to the police officer, and so because they're in a position of authority, and so I'll just give them my answer. And you might think, oh, if I'm a police officer, that just makes my job easier, so it's actually a good thing for me. And it's not. And here's why. It's your responsibility as the police officer to make sure that the young person understands their rights before you begin questioning them. If they do not understand that they are not obligated to respond to the person in authority, then guess what? All the information that you've collected is going to get thrown out in court because you failed to make sure that the young person understood their rights. So yeah, in the interrogation room, maybe you got exactly what you were looking for, but you're going to get embarrassed in court because the defense counsel is going to go through whether you appropriately gave the warnings and cautions to their client. And I've seen this happen, not when it comes to young persons, but I've seen police officers get embarrassed on the stand. I worked at a law firm during my field practice, and our client was before the court for drug trafficking charges. In this case, the police officer refused to allow our client to contact a lawyer. And the police officer basically felt that he was justified in not allowing this client, the person that he had just arrested, to contact the lawyer because the police officer was worried that instead of contacting a lawyer, the client would simply call a friend and say, use some code word like, hey, can you take the steaks out of the freezer? And steaks are drugs and the freezer is like the stash house, and that's going to be how the young person or how this particular offender is able to get rid of evidence. It's your responsibility as the police officer to make sure that you abide by the young person's rights, not just because that young person is entitled to those rights, but because if you don't do so, you're going to bring your own law enforcement agency into sort of disrepute in the public eye. You're not doing your job. People who are actually committing crimes are going to be let go. They're going to be walking the street free to commit new crimes because you didn't do your job, you didn't do your due diligence. So making sure that you are questioning the young person the right way is critical. So there are concerns about voluntariness of statements, especially when these statements are being made to a person in authority. But another concern is about suggestibility of a young person. Young people are much more suggestible than older people. And so this isn't just about making sure the young person understands their rights and freedoms. This is all about how you ask the young person questions. Because they're more suggestible, and I want you to think about this when it comes to Mr. Big cases as well. Because they're more suggestible, the phrasing of questions can influence the answer. The suggestibility concern is not just a concern for police officers. If you're doing research, if you are a forensic psychologist, you have to ask questions in a way that doesn't give the young person a sense of the answer that you're looking for. Especially though, if you're a person in authority, if you say a question like, you did commit that crime, didn't you? You are a gang member, aren't you? This suggestibility, the way that you phrase the question, is making the young person think that they're supposed to answer yes. This is also especially true for persons with mental disabilities, specifically persons with really low IQ who would meet the criteria for mental retardation, or persons who have fetal alcohol spectrum disorder. For someone with FASD, for example, they are especially likely to be vulnerable to suggestion. They are very vulnerable to peer influence as well. If they are around other people that they look up to or who are older than them, they'll go along with whatever that person says. And part of the reason is because of low IQ and cognitive impairments, they have difficulty understanding the world around them. They don't know how to behave in certain scenarios, what scenario they're in, why things are happening. So they're looking to other people for that advice or for that feedback. So if you're saying questions that are more in the form of a statement like, you did do this, didn't you? Or they were with you on that night, weren't they? You're basically putting the answer into that person's mind. So you have to be focusing instead on open-ended questions, phrasing things like how come, or using starting word of like what was it like on that night, as opposed to saying that you were drunk that night, weren't you? You were with that person, weren't you? Having these open-ended questions ensures that the nature of the answer is coming from the young person as opposed to the young person thinking that they're supposed to provide a specific answer. You definitely see this issue manifest in the interrogation of young persons, and that's why we have specific rules for admissibility, where the cautions, again, they have to be given to the young person in a language clearly appropriate for their age and level of understanding. So not just their age, but their IQ, because once again, young persons in conflict with the law are not just younger than other persons, they are also more likely to have a lower IQ, and so their ability to understand what's going on can be relatively limited. And because of this, they're more likely to actually confess than adults, because they believe that they're required to give a person in authority a particular statement or a particular answer, especially if a leading question is used. So they're not just susceptible to giving confessions, they're also more susceptible to false confessions. Also more susceptible to waiving the right to counsel, because again, they don't understand that having counsel is a right. They think, oh, I have to pay for counsel, or my parents are gonna have to pay for counsel, and I'm gonna get even more trouble, so I'm just gonna confess, or I'm just gonna answer these questions and say, no, I don't need to have a lawyer present. The admissibility of statements made by the young person to police is one of the things that is most likely to be litigated in court. So you have to take a lot of time to prepare the young person for the interview and what it's going to look like. We can now see a lot of examples of interrogations of young persons that don't look like interrogations at all. It's not the classic Hollywood movie where there's the good cop, bad cop, and one of them comes in with a phone book and is threatening the person. It's much more, I'm on your side, I'm your friend, I just want to hear what is actually happening. If you've seen the Netflix series regarding Brendan Dassey, I don't think there's any better example of how police have done a shitty job of interviewing young persons or interrogating young persons than the Brendan Dassey case, because it was clear that he didn't really understand what was going on, and he basically was saying whatever he could to what he thought would happen is, once they tell the police what they want to know, then they're going to let me go, and instead he's going to end up in jail for the rest of his life, basically.
Be honest. You went back into that room.
Don't let us down, Brendan.
We know you were back there.
These are the mistakes that you as police officers or persons interviewing youth simply cannot make. What's maybe surprising about Mr. Big cases or Mr. Big police investigations is that they are legal in Canada but not legal in the United States, because the United States believes that Mr. Big cases are especially susceptible to false confessions. And we've seen a lot of examples in Canada and even in Vancouver in the Lower Mainland of young persons and adults making false confessions to police during a Mr. Big sting, and then the case being thrown out in court. So for example, as I mentioned, I worked at a law firm and I was working for this lawyer, and he was one of the first persons to successfully challenge a Mr. Big sting operation, and he got the case thrown out of court. And what it related to was it was a young girl who was suspected of committing a homicide with a friend, and the police officers decided to pose as a gang organization or organized crime group. And they took the young person to Vancouver Grizzlies games, which is definitely a very old statement to be making, but they got to go to Grizzlies games, they got to stay in nice hotels, they went to fancy restaurants, and these were street entrenched youth that had never really experienced anything like this before. They had lived very, very difficult lives. And this gang that was basically police officers posing as a gang was giving the impression that they are now part of the family. And then the way the Mr. Big sting goes is they say basically the idea that, hey, if you have any criminal behavior that you've engaged in the past, let us know, because we'll be able to take care of it for you. Like, we have connections with police. If you tell us about crimes that you haven't been caught for, but you think maybe police might be onto you about, let us know, and we will use our connections in the police force to just make this go away. What the police in this case did, however, was make the girl believe that they were very susceptible to using violence against persons that did them wrong, and using threats towards the girl or to other people. And so this led to, for example, an inadmissible statement where the police officers posing as gang members said, you did kill that person, didn't you? And don't lie to us, you know what we're like. And so now this young person's thinking Jesus, these people have talked about hurting people or killing people in the past, and now there's clearly an answer that they want me to give them, and if I don't give them this answer, they might hurt me. So they provide this confession, and the courts in this case deemed that this is an inadmissible confession because it wasn't made of their own volition or free will. They felt that they were being pressured to say these particular words, and there would be serious ramifications if they did not say those things. The video that we'll watch is obviously going to go into more detail about these Mr. Big cases, and I recommend you pay special attention to what defense lawyer Marie Henein has to say about Mr. Big stings. She is, I think, maybe one of the best lawyers that Canada has ever seen. She also often gets scrutinized by the public or by the media because she takes on cases where, for example, she was the lawyer for Jian Ghomeshi, who I think was probably severely guilty of the offense, but she was able to basically find him not guilty of sexual assault. But she kind of got blamed for being the lawyer for Ghomeshi, and to me, she's just doing her job. So listen to her words about the issues that she takes with Mr. Big cases. I think that since the video that we'll watch came out and since Marie Henein's comments, police have become much more sophisticated and thoughtful in terms of how they implement Mr. Big stings. And an example that also applies to youth is the case of Wyatt DeBruin. Wyatt DeBruin was a teenager who was eventually sentenced as an adult, so he committed the crime before age 18, but the severity of the offense justified him being sentenced as an adult. He had committed several attacks on women jogging through Mackey Park in Delta, and then one of his attacks was against Laura Sendre, who was just a teenager walking through the park, and he attacked her with a metal pipe. He sort of tricked her into thinking that he needed help fixing his bike, and after the attack, Miss Sendre passed away from her injuries. One of the things that I haven't talked about regarding Mr. Big cases is that police can only attempt a Mr. Big operation if they have shown that all other traditional policing measures were unsuccessful. So if defense counsel is cross-examining a police officer and they ask the police officer, what did you try to do to identify my client as guilty? The police officer is going to have to show that they tried tapping the person's phones or surveilling the person or checking their school locker, all of these things that would be expected from traditional policing operations have to have been attempted and been unsuccessful to justify the Mr. Big operation. Why was this Mr. Big sting successful? Why was this Mr. Big sting allowed in court? It was allowed because of the circumstances surrounding the sting. Instead of police officers posing as an organized crime group, they instead created a less intense, less criminogenic scenario. They set up a Call of Duty competition that Wyatt DeBruin was rigged to win. So they set it up for him to win this competition. And then the police officers posed as video game developers. And I said, we're so impressed by you. We're going to take you to Vegas. We're going to have you test all of these different types of video games, and we're going to pay you. And as they get to know DeBruin a little bit better, they say hey, we're really powerful. We really like what you're doing for us. If you are ever in any trouble or you think that you've done things in the past that could get you in trouble, let us know, because we're rich, we have a lot of contact with the police, and we can kind of make these problems go away for you. So this is much different from the case I discussed earlier with the girls in Vancouver and the organized crime group, where DeBruin doesn't have this sense that if he says nothing to them, they're going to get angry with him. He's not talking to people that have murdered others in the past or brought harm to other people. He has no reason to fear saying, no, I've got no problems, I've never done anything wrong. They're not going to go back at him and say why are you not giving us the answer that we're looking for? And so ultimately DeBruin actually confessed and reenacted the crime for the undercover police officers, basically showing that there was no way for DeBruin to have been able to reenact that crime with that level of detail because the police had not released that type of information to the public. So the only way that DeBruin knew how to reenact the crime with that level of detail was if he was there, if he was the person responsible. So that's it, a nice short lecture for this week. But I am going to put a link in the slides and on Canvas to the Mr. Big video that you'll be expected to watch. We'll talk about it for this week's discussion, and the video will also be on the final exam. Until then, take care, everybody.